let me start by saying what they shouldn't do, and then we'll talk about what they should do. What they shouldn't do is ignore the lawsuit. They shouldn't take that summons a complaint and throw it in the desk and say, I'll deal with it later, or say, well, I don't want to deal with this lawsuit. This is a frivolous lawsuit, so I'm not even going to respond to it. That kind of action is fraught with danger for the physician, because what will happen is that the plaintiff's attorney will go to court and say, Judge, I served this doctor with the summons a complaint. The doctor hasn't responded to it. I want you, Judge, to hold him in default and give me an order saying that he's responsible for my client's injuries. And the court will do that. And the doctor will have lost any opportunity to defend the lawsuit. So what a physician should do when he or she receives a summons and a complaint in a malpractice lawsuit is one of two things. If he has medical malpractice insurance coverage, he should get that lawsuit over to his malpractice insurance carrier immediately. And there are a couple of reasons why he wants to do that. Number one, there's a provision in his medical malpractice policy that obligates him to immediately put the carrier on notice if he receives a lawsuit. If he doesn't do it in a timely fashion, the carrier can disclaim any coverage for him. The second reason why he needs to do it quickly is because the carrier needs to have time to evaluate the claim, set up a file, assign a law firm to defend the doctor, and have that law firm contact the plaintiff's lawyer to coordinate the appearance in the lawsuit on behalf of the doctor so that there is no default by the doctor. Now, if the physician does not have malpractice insurance, what he needs to do is quickly identify and hire an attorney who handles medical malpractice cases and have that attorney reach out to the plaintiff's attorney and coordinate an appearance in the lawsuit on behalf of the doctor, again, so that the doctor doesn't go into default and risk losing the lawsuit before he ever gets a chance to get into it to defend it. Well, what the physician should expect is a process that's going to take a reasonably long time to work itself through to an outcome. Here in New York, in the metropolitan New York City area, medical malpractice lawsuits can take an average of about 4 years from the commencement of the lawsuit to resolution of the lawsuit. Some move a little bit more quickly, some move more slowly. But what the physician can expect is a lengthy process where the physician is not going to be dealing with it on a day-to-day or even week-to-week or month-to-month basis. The physician is going to have an attorney representing him. The attorney is going to be handling the day-to-day work on the case, not going to be contacting the physician every day to discuss the case. So the physician, once he has his law firm in place, defending him in the lawsuit, either through his carrier or privately, the physician can comfortably resume his daily activities, his daily practice, not worry too much about the lawsuit, let the lawyers handle the lawsuit. From time to time, the physician will be called upon to participate in certain aspects of the lawsuit, but they're really relatively few and far between. The physician can expect an initial meeting with the lawyers to describe the care and treatment of the patient, the interactions with the patient, to review medical records and the physician's own medical records regarding the patient. The physician certainly can expect at some point in the lawsuit that he's going to have to go through a deposition where he will appear in a lawyer's office and he will be questioned under oath about his involvement with the patient, and he will have to answer questions. And a deposition in a lawyer's office is considered the same as if that doctor were testifying in a court at trial. And so there's going to be thorough preparation for the deposition with his lawyer. and there's going to be very serious attention to the questions that are asked and the answers that the physician is going to give. And beyond that, the physician probably won't have significant involvement with the lawsuit until it gets to trial stage if it's not settled. And then there's a lot of involvement that goes on at the trial level. What I tell every physician that I am representing at a trial is the following. I tell the physician, I'm the producer. Think of this as a play. I'm the producer. I am going to hire all of the participants for the trial on your behalf. I'm going to hire the experts. I'm going to bring in any other witnesses. I'm going to arrange for all the people to be at the trial that I want to participate on your behalf. I tell the physician, I'm also the writer, the playwright. I'm going to tell you what I want you to say when you're on the witness stand. I'm the director. I'm going to tell you how to say it. I'm the choreographer. I'm going to tell you how to walk, how to sit, how to turn and look at the jury when you're testifying. I'm also the dresser. I'm going to tell you what to wear. And so I am in control of every aspect of this trial from our side. You take your cues from me. You do what I tell you to do. You answer the way I tell you to answer, and you act the way I tell you to act. And that will give you your best shot at having a successful outcome on the trial. What I tell my physician clients is that while I understand that this is a very personal event to them, and it may or may not be highly personal to the plaintiffs in the case, they really have to view this whole process as a business process. At the end of the day, a lawsuit and a trial is nothing more than a negotiation tool to achieve a business result. You know, that business result is the plaintiff wants a sum of money from the physician or the physician's insurance carrier. And so we try to keep the focus on the business and try to keep emotions out of it as much as we can. And so what I tell the physician about settlement or going to trial is make that decision a business decision. Don't make it an emotional decision. Sometimes the proper business decision is to settle the case. Why? One of the things we know is that when a case is settled, there is no finding that the physician committed malpractice. There is no admission that the physician did anything wrong. In fact, the settlement documents that we prepare specifically state that the settlement is not deemed to be an admission of any wrongdoing or malpractice by the physician. So, one benefit to settlement is you avoid the possibility of a jury formally finding that you committed malpractice. Another benefit to settlement is we take this important decision out of the hands of these 6 people that we pulled it off the street, and we put it into our own hands. And it's always best, if it can be done, to resolve these matters through our own efforts rather than simply letting this group of strangers resolve this very important matter, because we never know. No matter how strong a case we think we have, or how strong a case the plaintiff thinks he or she has, you never know what a juror's going to do. Jurors have been known to do some very strange things. So there's a huge element of risk when you let a case go to verdict at trial. And so we tell the physician, look, there are some cases that simply cannot or should not be settled. We have to go to the jury and let the jury decide it. There are plenty of those cases. But if there are cases that can be settled and that should be settled, it always makes sense to seize that opportunity to settle those cases rather than roll the dice with a jury. There is a national data bank of adverse determinations made against physicians, whether it's licensing determinations or hospital privileges determinations or malpractice verdicts. And so if there's an adverse verdict against a physician, it will be reported to that data bank, and that is called the National Practitioners Data Bank. So there's a report that will be filed with this data bank. And there are many entities in the healthcare field that have access to these reports at the data bank. Hospitals have access to them. State licensing boards have access to them. Healthcare providers, HMOs, and health insurance companies have access to them. And it could be that based upon an adverse malpractice verdict, action could be taken against the physician with respect to his or her license in any given state. Action could be taken with respect to his or her privileges at hospitals. Action could be taken by health insurance carriers or HMOs where the physician is a participating provider. So while we usually don't see many of these adverse actions based on a single adverse malpractice verdict, if there are enough adverse verdicts against a given physician, he or she might be at risk of these other entities taking some type of action against him or her based upon a series of adverse verdicts. Settlements are reported as well, but because a settlement is not a formal finding of liability, it doesn't carry as much of a negative implication as a jury verdict finding the physician liable for malpractice. So I would say, settlements, although they are also reported to the data bank, they don't carry the same degree of risk of spilling over into the physician's practice and professional life as an adverse verdict does. I really don't see it affecting it significantly one way or the other. And it's really very difficult at this juncture to really hypothesize how this will play out over the years. Theoretically, there will be many more people accessing health care. That means there's always the opportunity for more claims of malpractice. But even now, people who don't have health insurance coverage, if they get sick, if they get injured, they're going to go to a hospital or a healthcare provider. They're going to get treatment, and it's just as likely that they will have a malpractice claim than if they had insurance coverage and they went to that same hospital or provider. So I don't see the Affordable Care Act as significantly impacting the medical malpractice litigation one way or the other. Don't forget, malpractice lawsuits are totally driven by state law. There's no federal law affecting medical malpractice lawsuits. So I don't see any state laws changing at all when it comes to medical malpractice litigation based upon the Affordable Care Act.